September 28th, 2011. Davina, Andrea, David, DJ, and family. I hope this correspondence finds you all well. For the past 2 months, Sharon and I have been estranged as a result of unfortunate events that occurred the night of July 22nd, 2011, at our residence in Arlington, Virginia. I am certain that you all have some knowledge of the separation that has resulted in our absence from one another's lives. However, I am not certain to the depth of your understanding and feel it incumbent upon me to clarify my position and inform you of the fact, despite the risk involved with doing so to my personal freedom. I understand that family can be unforgiving and can see how and why people in relationships sometimes feel the need to hide personal issues and conflicts from them. Nevertheless, I think I owe it to you all to inform you that I have neither abandoned or willfully did anything to hurt Sharon. We have been together for close to 20 years, and she has been nothing but a friend to me. You all have been nothing less than family, and hopefully one day we will all be reunited. However, misunderstandings and mistakes on both of our parts have led to the involvement of a legal system that cares nothing about any of us, and I am now prohibited from having contact with Sharon and or returning to our residence. Therefore, I will just have to trust that this sincere, responsible, and heartfelt effort will not be used maliciously against me. I no longer have a mother or grandmothers, but have loving, caring, concerned sisters, and if the shoe was on the other foot, I would only respect someone else doing for me what I am now trying to do here with no ulterior motive other than that which is right. The events in question resulted in an emergency protection order that should have expired in 72 hours, sometime on July 27, 2011, the Tuesday following the Friday night of the events mentioned earlier. First and foremost, this order was both excessive and unnecessary because I am not and have never been a person that anyone needs protection against. I have always respected the law, others' rights, and most importantly, cherished my freedom above everything. Unfortunately, the U.S. legal system is not aware of this fact and only sees me, Sharon, and the majority of the rest of us as simply a number. Without going into any long-winded and questionable details, the stressful events and conflict of 7/22 resulted in unintentional, incidental, physical contact with Sharon that resulted in emergency services being summoned, the beginning of a legal process that is now out of both of our hands, despite our desire to resume our relationship. This EPO was modified orally by the court on 7/25/2011 and extended until my next court appearance. This date, unfortunately, was scheduled some 2 months later on September 19, 2011, 56 days later to be exact. During that time, I have had no option other than to take up residency elsewhere. Until recently, I have been living with one of my sisters. On September 19th, despite the written opinion of a noted doctor that it was not appropriate for me to appear in court, I appeared anyway. The doctor said that I needed a few more weeks to recover. However, contact with the unconcerned public defender representing me convinced me that if I wasn't in the hospital, I needed to be in court, despite the qualified medical opinion of the neurologist who had evaluated me for epileptic seizures 24 hours a day between 7/12 and 7/16 at the Georgetown University Hospital Department of Neurology, and confirmed seizures, epilepsy, and episodes of organic psychosis. This sleep study was attended around the clock by 3 of my sisters, videotaped 24 hours a day, and monitored via a telemetry device connected to my head, analyzing brain activity. On September 16th, before my release from the hospital for my own legal protection, I requested via my attorney a continuance of my case, informing him of my diagnosis and the doctor's recommendation. Nevertheless, I still felt the need to appear, out of respect for the court, the attorney, and most importantly Sharon, and was granted a continuance. Unfortunately, the court has not altered its order, and this new date has extended my prohibited contact with Sharon and/or return to our residence for another 2 months to sometime in November. As supportive as my family has been so far, they have their own issues and lives. I have since moved to my own place, though my permanent residence and mailing address is still 2730 South Beach Street. It was my responsibility to inform the court of any change of address and or living arrangement, and have since done so through the public defender as an officer of the court. I thought about conferring with the attorney before sending you all this correspondence, but I feel more obligation to you all and actually trust you all and Sharon more than him, and am opting not to involve him, despite his obligation to defend me. The outcome of this situation is yet to be decided, but I hope it works out best for both of us. I hope that one day Sharon and I will be reunited, but if this does not happen, I want you all to know that I still love her and hold no animus towards any of you, and if I am still residing here, you are all welcome to visit me. Take care and best wishes in all your endeavors. Yours truly, to whom it may concern.